Mr. Judy is here today after failing to appear before referee Croteau on March 3rd, 2022. Bond is currently set at $2,078. This is the third bench warrant. He reports no employment. Last payment made on this account was in October of 2020. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on March 22nd, 2023 at 8:00 a.m. before this court.
Mr. Judy, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on March 22nd, 2023 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
Yes, I think so.
And how much can you post in a bond?
I'm not sure yet. I'd have to figure it out.
Okay, well, I'm looking at it as your third bench warrant and you haven't paid in now 2.5 years. So court's taking all of that into consideration. What I'm gonna do is I'm gonna set your bond in the amount of $500. If you're able to post that, you'd be able to be released. Do you have any questions?
No.
Okay,
Yes,
thank you,
Monday,
sir.
March 13th, 2023 at 8:40 a.m. Attorney Kelly Podolsky represents plaintiff and Attorney Kim Savage, defendant.
Good morning to everyone. I'll
Morning,
start
Greg.
out the note that in this matter, the matter is before the court for a entry of a default judgment. I do note that Ms. Savage has in fact filed an objection. Ms. Savage, I'll ask you, did you file a motion to set aside the default or not? I didn't see that, but
We did, Your Honor, and you denied that motion. That would have been last fall.
okay.
Actually, it was a stipulation to set it aside.
Oh, we did a step to set it aside?
Yeah, and Your Honor denied it, and I don't know the reason, and in all honesty, I didn't inquire.
Okay. Okay, Ms. Podolsky, what's your response to the objection?
Thank you, Your Honor. We just received the objection on Friday. I was out of the office last week. However, it did come through Friday afternoon. This matter, as you know, has been open for at least 6 months now. Because of the default, we were not ordered to participate in mediation. So these parties have not participated in mediation. We did attempt contact with defendant through counsel to try and resolve this matter. We did not hear back. So we did notice up a default judgment for entry today.
Okay. Well, what the court's going to do in this matter is obviously the court has denied the request to set aside the default, so I'll keep that in place. But the court will allow the defendant to be involved as it relates to the disputed issues, and the court is going to send the matter to mediation. Ms. Podolsky, you obviously, I know Mr. Brundage is going out a few. Would you be able to get it into mediation in April, do you believe?
I will reach out to Mr. Brundage's office today. Last I knew, he was scheduled out at least through mid-April, but we will reach out to him today. If the court would like us to select a backup, I would offer Lisa McNiff as an option.
Would Ms. McNiff work with you, Ms. Savage, as a alternate?
Also acceptable, Your Honor.
Okay. Well, what I'll do, Ms. Podolsky, is set the mediation for April, and we'll set a settlement conference date in this matter set it for May 1st at 1:30 p.m. Parties are required to be present. That'll be by Zoom still, but we'll see where we're at that particular point. So I'll Ms. Savage, I'll ask you, again, kind of your action initiating this, that you would do an order setting the matter for mediation in April with Mr. Brundage and Ms. McNiff as a backup, and then we'll send you notice of the settlement conference in this matter. Ms. Podolsky, with that, do you want to proceed with your pro-con at this point? We can do that. Or you can wait, it's up to you.
I'll wait, just because if we don't resolve this at mediation and we do have to have a trial, I don't want to forget that we ran that this morning.
Okay. Well, okay, what we'll do is we'll wait on the pro confessor hearing and we'll proceed in that manner, and we'll end this matter and allow you to go and have a good day.
Hey, how's that? Can you hear me?
Yes.
Wonderful.
Teresa Green versus Richard Green Sr. Intervening party, Jennifer
Court will
Wolf.
note the appearance of Mr. Vanderhorst on behalf of the defendant, Ms. Podolsky on behalf of the intervener. In this matter, the matter is before the court on the intervener's notice for entry of consent judgment. Ms. Podolsky.
Thank you, Your Honor. We were here a few weeks ago and we placed an agreement on the record as it relates to custody, parenting time, and support of the minor child in this matter. We have noticed this up for entry today. We did not hear back from defendant regarding income. We did understand he was on Social Security disability. We used an amount that was known to us from the Social Security Administration as being in the general ballpark, if you will, of a monthly amount. It was just over $300. Unfortunately, I don't believe counsel for defendant had been able to reach him. And because of that, we have noticed this up for entry today.
In regards to the order does appear to correct what we put on the record and what Mr. Green agreed to. My concern is just I need to confirm with him his monthly Social Security that he is receiving that was put in the Uniform Child Support order, just to confirm that is correct.
Okay.
So,
Mr. Green, are you aware of what your monthly disability is?
I think it's 0 now, Your Honor.
Okay, well, you're going to have to provide some information to Mr. Vanderhorst, and he can provide it to Ms. Podolsky.
That's going to be difficult, Your Honor. I'm in a jail cell with no bond.
I understand, but well, if you can contact somebody to get some documentation or just provide it to Mr. Vanderhorst when you can. I understand.
Not
you're in
likely.
jail. So, Ms. Podolsky, we're just awaiting front of the court. We haven't had the approval yet, so when we do, we can get it entered at that time. And Mr. Green, when you can get the income information provided to Ms. Podolsky, and then maybe we can resolve that issue as well.
No, I can't wait.
Okay. Okay, thank you. The court will end this matter at 9:05 a.m. You're free to go. Have a good day.
Thank you.
Thank you, Your Honor.
6 a.m.
Court will note the appearance of Ms. Podolsky on behalf of the plaintiff, the defendant appearing in pro per. This matter is before the court on the plaintiff's motion for modification of parenting time. Ms. Podolsky.
Thank you, Your Honor. The judgment of divorce in this matter entered in June of 2018. That order granted the defendant father standard parenting time. Since the entry of the judgment, he has not been exercising his parenting time or even a fraction of his parenting time. And in 2022 alone, only exercised 14 overnights. To date, he has not seen the minor children since August 28th, 2022. And he has moved to Indiana. He did that in September of 2022. And his new residence is 2 hours and 45 minutes away from the plaintiff. He made this move without permission from the court. He has not been participating in the medical and educational decisions of the minor children. My client, however, has been keeping him regularly up to date on all of their medical needs, including a tonsillectomy had by one of the minor children back in February of 2022 that the defendant failed to attend. He has sporadic phone contact with the minor children. When he does have that phone contact, it often lasts less than 5 minutes at a time. My client has been in contact with the defendant's mother. She organizes visits for defendant's mother, organizes meals for them to have with their paternal grandmother. We are asking this court to modify the judgment of divorce and order parenting time at all times and places as the parties may agree, because essentially that is what has been happening now since the entry of the judgment. Further, the judgment of divorce does provide language that states the defendant's father can only have contact with the minor children if it is supervised by the defendant. That language needs to remain in any and all future orders due to the nature of his felony convictions. So we're asking at this time that the court modify the judgment of divorce and order that defendant's parenting time occur at all times and places at which the parties may agree, that transportation for his parenting time be provided by defendant himself, and that he is to be present for that transportation due to the language that is necessary regarding his father. And we believe it's important that he provide that transportation because he did make this decision to move without permission from the court, and again is 2 hours and 45 minutes away from the minor children.
Okay, thank you. Mr. Blunt, what's your response to the motion?
Based on what I know of Michigan's family laws, last time I checked, as long as the domicile of the children did not change, that should not have any pertaining to me. Not to mention, as it was either become homeless or removed, and I wasn't prepared to lose even further rights to my children by becoming homeless.
Okay, well, let's address the issue. I'm not concerned much with your move, but the issue
Right.
is she's asking to modify parenting time that would say that all times and places to which the parties may mutually agree. Is there any problem with that?
No, and as it was, I've made numerous contact times, both by text message and by phone call to Miss Coy about meeting up halfway and even giving gas money so that way she can return back to her homestead when becoming with my parenting time.
Okay. Anything
And
else?
she
that you-
has, and she
Go
had,
ahead.
I'm sorry, my apologies, Your Honor, but she has refused each and every time.
Okay. Anything else? Sir?
Yes, also based on with the medical needs and dental and everything else, there was times that she never even communicated to me on half the stuff at all until after it happened.
Okay, well, that's another issue. And again, if she doesn't do that, you have a right to petition the court to enforce that. But based upon what you said, that you don't have any objection to modifying parenting time to say all times and places to which the parties may mutually agree. So if there's no objection, the court would order that, okay?
Well, I have an object to that because that's not exactly fair.
Oh, you are objecting to that? I thought you said you had no objection to that.
I'm sorry, Your Honor, I did not mean to have that come across like that.
Okay. Well, with that in mind, what the court will do is the court will, does believe there's a sufficient basis for modification. Court will send the matter to the referee for an evidentiary hearing, and you'll get notice of that probably the end of this week, sir, and then be prepared to have that particular hearing, okay?
All righty.
Okay,
Your Honor, if I may, make a motion at this time that the referee hearing occur in person for all parties. My client is hearing impaired. She utilizes the reading of lips to assist her, and that is very difficult to do on Zoom. So we're asking that any evidentiary hearing be a requirement in person for all parties.
okay. You understand that, sir? You'd have to come back.
Okay, if that's the case, then I require that this being during the week, Monday through Thursday, because I work Friday, Saturday, and Sunday.
Okay, well, what we'll do is we'll try to accomplish that. If, for instance, if you get a hearing notice and the referee sets it for a Friday, then what you're gonna have to do is contact Ms. Podolsky and we'll try to move that, okay?
All righty.
So we'll set it, Ms. Podolsky, you can why don't you do that, put it in an order that there'll be a referee hearing, because we'll refer it to the referee, but if you put that it would be in person and that it would occur Monday through Thursday, then hopefully we can eliminate that conflict with Mr. Blunt's schedule as well.
Okay, thank you.
Okay, thank you all. Court will end this matter at
Louis
9:13
Adams
a.m. You're free
versus
to go
Whitney
ahead.
Adams. Today is Monday, March 13, 2023 at 9:15 a.m.
Court will note the appearance of Ms. Podolsky on behalf of plaintiff, Ms. Henderson on behalf of the defendant. This matter is before the court on the plaintiff's motion for temporary custody, parenting time, exclusive use, return of property, and other relief. And the court does note that Ms. Henderson has filed an answer. I've reviewed that. Ms. Podolsky, you can proceed.
Thank you, Your Honor. I would note that this was filed on February 7th. The court was kind enough to allow us to schedule this for a Wednesday motion hearing on February 22nd, but due to the ice storm, we did have to cancel it, and it was rescheduled for today. These parties did reside together up until the time of filing and February 6th, 2023. They have 2 minor children together. At that time, the defendant did move from the marital home. I do not believe there is a dispute over awarding exclusive use of the marital home to my client. I believe that has been resolved. However, as it relates to custody and parenting time, there is no order in place. While these parties have been able to somewhat work together, a specific schedule does need to be ordered. These parties have both been with the minor children since birth. However, it has been the defendant who has absented herself from the home over the years for significant periods of time, with one period lasting up to almost 1 year entirely. The plaintiff has been the primary caretaker of these minor children. He has been able to ensure that they are cared for while he is at work. He handles their schooling and all of their medical needs, despite the fact that he does have a full-time job that sometimes has some weird hours because it is factory work. However, he does have family in the area who are able to help him when he does have to work. The defendant, to our knowledge, does work at a restaurant. She often works late nights because of the hours of the restaurant. We do have a proposed schedule outlined in our motion that we believe would be in the best interest of the minor children and also accommodates the work schedule of both parties. As previously stated, it has been the defendant who has absented herself from the home. It is leaving plaintiff to be the primary caretaker for these children. We do believe it is appropriate at this time to award the parties the joint physical and legal custody of the minor children. We are asking for the parenting time schedule that we've outlined in our motion to be ordered. When the defendant did leave the home, she took almost everything from the home, all the way down to the bath towels and the dishes in the house. We do have photographic evidence of this. My client is currently working on a list of property that he would like returned to him. And I do believe we can work that out with defendant's counsel to assure the return of any of that property. So today, I believe the issues that do need to be addressed are custody and parenting time and child support.
Okay, thank you. Ms. Henderson?
Thank you, Your Honor. That is correct that we are not contesting exclusive use being granted to plaintiff. My client has no desire or plans to return to that home that is owned by plaintiff's father. It is untrue, Your Honor, that plaintiff has been the primary caretaker of the children. The children are currently 9 and 12. My client has arranged her work schedule to be flexible enough to be able to get the children to and from school. And then she has family members watching them a couple nights a week that she does work. She never works past 9 o'clock. She is able and fit to provide care and custody for the minor children. We outlined in our response to the motion, Your Honor, plaintiff's work schedule that is on average 100 hours a week or more, where he leaves the house early in the morning, does not come back until 11 o'clock in the evening at night. He works most weekends, and so far since the separation, any time that he was not working and asked my client to see the children, she accommodated that. So essentially, if he is granted joint physical custody, the children will be in somebody else's care rather than his care, simply due to his unavailability. He works in a factory with mandatory overtime. It's not something he can flex or change his schedule to accommodate the children. My client is able to do that. We provided her work schedule in our response to the motion. She works Wednesday, Thursday, Friday, and Saturday nights. And she is she works Thursday, Friday, and Saturday from 4 to 9 p.m. and the first Sunday of every month from 10 to 3 p.m. And at that time, the children are able to come to work with her and do homework and whatnot, be supervised at that time. So, Your Honor, my client is absolutely able and willing to provide care for the children. Previous separations of the parties occurred prior to filing for divorce. They were all due to domestic violence against my client by plaintiff. There is currently a personal protection order that entered by this court and was served upon plaintiff last night. So, Your Honor, that should absolutely be considered by this court in making a determination on custody and parenting time. As it relates to the property issues, Your Honor, my client moved out in the beginning of February after filing. Since that time, we have been asking for a list of property that Mr. Lewis Adams would like returned to him. We have not received that list. My client left children's furniture in their bedrooms. She left one bedroom set. She left towels and kitchen utensils and other household items, as well as a dining room table and chairs. She did not clean out the house as stated in the motion. She took approximately 1/2 of the household items, enough to get by and enough to provide for the children. There's children's items left in the marital home as well. So, Your Honor, we are disputing that portion of the motion at this time. We're asking that my client be granted physical custody of the children, with plaintiff having parenting time when he's available to provide care for the minor children. Again, that may be difficult for the court to determine given his 100 hours plus per week of work time. We're asking that child support be granted in accordance with the Michigan child support formula. We're not disputing exclusive use. At this point, we are not disputing joint legal custody, as we understand that is the default of this court. So, Your Honor, joint physical custody is not in the best interest of the children. We're asking that my client be granted physical custody. One other portion of the motion was related. We're not objecting that the children remain in that school district. In fact, my client secured her housing within about a mile from the marital home, so the children could continue attending that school district. So that is not something that we are contesting at this point. Thank you, Your Honor.
Thank you. Anything else, Ms. Podolsky?
Thank you, Your Honor. Since the filing of this motion, my client has been able to change his work shift to the first shift at the factory. As you can see, he's trying to connect to audio and he is at work right now. We deny that he is working 100-hour weeks. Yes, there is overtime at work. However, it is never a guarantee, just like any job. We do believe it would be very inappropriate for these minor children to be going to a restaurant and bar to do their homework and wait for their mother to get out of work. We do believe what is in these children's best interest is to have a schedule of joint physical and legal custody with the schedule we have outlined in our motion to accommodate the work schedule of both parties. We deny that there has been any domestic violence in this matter. I understand, as counsel has stated, that a PPO may have been served last night. I have not seen that PPO. I understand that one was requested and granted several weeks ago, actually back in February, but was never served on my client until apparently last night, the night before this hearing. Since the entry of that PPO, however, the parties have been having parenting time exchange and cordial communication regarding the minor children. So I just find it interesting that she waited until the night before this hearing to serve that PPO. We do believe that is disingenuous. So we are asking this court to enter an order of joint physical and legal custody with the parenting time schedule that we outlined in our motion. We'd agreed to continue schools and exclusive use of the marital home to my client.
Okay. Well, apparently it's not in dispute is that the children would stay in the district, so the court will order that, as well as grant plaintiff exclusive possession of the marital residence. As that's not in dispute, it's not in dispute either that the parties would have joint legal custody. So the court will grant that as well. As it relates to the physical custody, what the court's going to do in this matter, the court is going to grant joint physical custody to the parties based in parenting time based upon any schedule that the parties can arrive at as mutually agreeable. If they cannot agree, then it will be alternating weeks on exchange on Friday at 6:00 p.m. through the following Friday at 6:00 p.m. Support will be consistent with the schedule and the guidelines in this particular matter. The court will not take any preliminary matter as it relates to the personal property, allow the parties to attempt to work that out. If they're not able to work that out, then we will address it at a future hearing. So, Ms. Podolsky, you can prepare that order and submit under 7-day notice.
Thank you.
Okay, thank you. Court will end this matter on behalf of the plaintiff, Mr. Fisher on behalf of defendant. This matter is before the court on the plaintiff's motion to enforce judgment of divorce, sale of real estate and other relief. I've read the motion. I've also reviewed Mr. Fisher's answer in this matter. Mr. Fisher, when I review the answer, a little bit nebulous as to when your client is going to be able to, again, you said he couldn't file the taxes until he had the money to pay those, and that was preliminary to his refinancing. When's the, I guess you'd say, a drop dead date that he's going to have that filed, done so that he can refinance?
Well, he did have his tax returns prepared. He didn't get a 1099 until mid-February. So
I was asking about when he's going to file them. I don't care when he had them prepared. I understand he did that.
He has to raise the money to file it, and what he's asking for is an extension of 90 days, because during that period, not only does he raise the money, but then they have to give the final approval, and then they have to schedule a closing date.
No, you're not asking for an extension of 90 days. You're asking for 90 days from today's date.
Yeah, that's correct. And Your Honor, if I may say so, part of this problem is not the problem of the people that are in this hearing. It took 52 days for the judgment of divorce to be entered. And almost all 99% of the judges I am acquainted with always say 60 or 90 days after the entry of the judgment. This one, to my chagrin, said December 31st. So it took 52 days to get the judgment entered. It was not entered. The settlement was in September. It was not entered until November. I didn't get the judgment till November 9th. And the lender wouldn't do anything regarding the loan until they had a copy of the judgment and a copy of the warranty deed. And that's the problem. We right now he's at the finish line. He's done everything. He filed the application 30 some days before I got the judgment.
Okay. Ms. Podolsky, what's your response to Mr. Fisher's answer?
Thank you, Your Honor. We mediated this matter back in September of 2022. The December 31st deadline, that date was a mediated date. That was agreed to by all parties, including defendant. And in agreeing to that, that's giving assurances that he has the credit score, the funds available, whatever he needs to do to get this home refinanced. And that is the mortgage and the home equity line of credit. Mr. Fisher has outlined a timeline in his response. You can see that the deeds were all prepared, signed, entered, and recorded at the Register of Deeds. At this point, we are now at March 13th. So even with the judgment of divorce entering back on November 3rd, we're at March 13th, and this is still not done. And the defendant is now requesting 90 more days from today's date. In the meantime, the home equity line of credit, the mortgage, continue to sit on my client's credit report. This is prohibiting her from making her own purchases, securing her own permanent residence because this has been outstanding. We will acknowledge that the skid steer was refinanced, or the loan at least was transferred out of my client's name after the filing of this motion. So that is no longer an issue, but we are asking this court to order the sale of the marital home. This was all negotiated at mediation, the possibility of this refinance not occurring and how the sale of the home would then proceed and what each party would receive from the proceeds of the sale of the home. So we're asking the court to enforce the judgment and order the sale of the home.
Okay,
Your Honor, if I could just quickly, and I mean quickly respond.
Mr. Fisher, I don't need anything else. Thank you. What the court's going to do is court notes that, and court does note that it was by agreement, but court also notes that things come up and sometimes the refinancing cannot occur for various reasons, which is obviously what's occurred here. What the court is going to do is the court will grant the defendant's request for an additional 90 days from today's date. And if in fact the refinancing doesn't occur within that 90 days, then the court would order the sale of the property on that after that 90th day. So Mr. Fisher, I'll ask that you would prepare that order and submit under 7 days.
Thank you, Your Honor.
Thank you. Court will end this matter at 9:32 a.m. You're free to go. Have a good day.
Tom, can you hear me?
I can hear you.
All right, Attorney Toth.
Yes, ma'am.
Elizabeth Klein versus Matthew Klein.
Court will note that this matter is before the court on the plaintiff's notice for entry of judgment and the UCSO. Mr. Schaefer has filed kind of an extensive objection to that. Mr. Toth, if you would, I guess, address the objections, and then we can go from there.
I will do so, Your Honor. I've had an opportunity to review the objections that I received Friday afternoon, and I've had an opportunity to go back and look at the what I'm going to call the video transcript. I guess we have the advantage of being able to go back and look again at exactly what Your Honor said. I think, first of all, Your Honor, what I would like to do is to focus on the equalization of the parties, because quite frankly, I think we're actually $32.89 apart, and I'll explain why. Mr. Schaefer's what he calls his judgment of divorce equalization chart does not include the award of attorney's fees to his client. If we look at the bottom of the chart where it's 1,342.20 awarded from plaintiff to defendant, what that represents is the Cigna stock. It's the same number. In my view, the $5,000 should be added to that also, because there was an award of $5,000 that was directed to his client. And Your Honor, then unfortunately, what Mr. Schaefer's equalization chart totally ignores was contained on page 8 and 9, even of his proposed judgment, and that's the reimbursement from the defendant to my client for expenses. And the amount of that was $12,556. And that's consistent in both of our judgments, Your Honor. I should say that I went through each of the individual provisions within our judgment, and the numbers are the same. It's the way that Mr. Schaefer has chosen to allocate and apparently ignore. So my view, Your Honor, is this, is that Mr. Schaefer claims that it's $8,571.38 that's owed to the plaintiff, my client, by Mr. Klein. He ignores the $12,556 that is owed from the defendant to the plaintiff. And if you add those numbers together, it's $21,127.38. And if then we subtract the $5,000, the attorney fee that's owed by my client to Mr. Klein, we come up with $16,127.38. Your Honor, my bottom line the bottom line equalization number was $16,094.11. That's $32.89 difference. My number is actually more favorable to Mr. Schaefer's client than his. Again, we're talking $32 or $33. So in essence, Your Honor, when we went at it two different ways, and it's unfortunate, but it's consistent with this case. The parties have trouble doing things according to the same process, and apparently the lawyers do also. I've gone through, and I don't quite understand. I understand that maybe Mr. Schaefer missed the reimbursement from defendant to my client, but what I don't understand, Your Honor, is somehow the notion that the attorney fee should not be offset. And I had an opportunity to go over the video, and at the outset of the hearing, or of your finding, Your Honor, you said, and I'll quote, "After considering offsets and the debt in this particular matter, I will tell the attorneys, I am not going to give you a balance at the end saying this is the amount. You have to go through and take each item of property individually and then offset those to come up with the final number in the end." That was at the outset of the property finding in the case, Your Honor. And then I'll jump to the very end of the proceeding, and that happened at the 1 hour, 30 minute, and 34-second portion of the hearing. And this was a situation where Mr. Schaefer was asking for clarification about the attorney fees to be paid. And Your Honor stated, and this is specifically, again, I'll quote, "Well, what happens is we are going to have to calculate and offset all these things. So I don't know, but the court would order that would be paid within 90 days from today's date." The court referenced offset at the very first moment of your finding, and pursuant to the question from Mr. Schaefer, the subject matter of offset comes up again. So as a consequence of that, Your Honor, my belief, again, is that why aren't we including the attorney fee in the offset? It's illogical. Everything else, Mr. Schaefer or the defendant agrees should be subject to offset, but it's that one item that isn't. And it's illogical, Your Honor, and it's absolutely inconsistent, not only with the theme that you identified for us when we first appeared before you, but it's also contrary to the specific answer to the inquiry by Mr. Schaefer. And I'll simply repeat that I will tell the attorneys I am not going to, well, I'm sorry, it goes back to the 1:30:34 portion of the hearing, and we're going to have to calculate and offset all these things. And that's exactly the way I approached your finding, Your Honor. And again, I think that if we include the offs or the $12,000 $556 reimbursement from defendant to Ms. Klein. And if we offset the attorney fee award, our numbers are very, very similar. So I would suggest, Your Honor, overall, we've arrived at the same place. And Mr. Schaefer would, again, I don't understand why the offset would not apply to the attorney fee. So that would be my overall general impression, Your Honor. I would state that there's been no objection that I think we both have the same numbers for the 2 child support orders. And now I would move on to spousal support. Your Honor, I went back and listened to the video, and I will concede that at that point, or in regard to the spousal support, quote, the court will grant to defendant transitional spousal support in the amount of $36,000 in gross payable at a rate of $1,000 per month. This amount is not subject to modification, is forever barred after the 36 months. So the form that I submitted and that was objected to talked about termination at death or remarriage. I'll acknowledge that was not in the video. As a consequence of that, Your Honor, I would look at it as follows. If in fact it was the intent that that's an alimony and gross award, I think the easiest way to handle the $16,094.11 offset would be to offset that against the alimony. It's a lot cleaner and it's a lot easier, and it really addresses this argument regarding the various tax rates. So if it's an alimony and gross award, there's no reason that shouldn't be included in the offset. It's a lot easier than the gross up or the gross down, or however you want to look at it, comparing the pre-tax dollars to the post-tax dollars. So I think that would be, again, the cleanest and the easiest way would be to simply have that money that's owed after it's all said and done of the post-tax dollars of $16,094.11. It could be just offset against the alimony, and we don't have to go on to the adjusting the retirement award. It could remain at that $41,000. Now that brings me to another objection that's been stated by Mr. Schaefer, and that's number 6. And it has to do with the gross up, if you will. And that is that he somehow believes that it should be a 12% rate of the defendant. Well, Your Honor, the actual rate is not 12%. And I'm quoting the Internal Revenue Service, and this is available to everybody. And from the actual rate is 22% for Mr. Klein, because he earns more than $41,776. So somehow, if his tax rate should apply, then it actually should be the 22%. And when you add in the state tax, my 25% that I used is actually a good number. Actually, it's favorable to him. But that being said, Your Honor, it really makes no sense that we're talking about using defendant's tax rate for anything. And again, I want to be clear that the reason that this is an issue is because at the end of the day, my client owes the defendant $41,000 or such in pre-tax dollars in retirement. And Mr. Schaefer's client owes my client approximately $16,000 in post-tax dollars. And so we come up with our apples and oranges evaluation of this. So the question becomes, what is the amount of money that's going to have to be paid that would provide my client with the $16,000 in post-tax dollars, since it's coming from pre-tax dollars? So again, this is all applies to the plaintiff. It has nothing to do with Mr. Schaefer's client's tax rate. And so the idea here is what we have done is to say that to get the equivalent of the $16,000 in retirement money, it has to be grossed up. And that's basically what I did, Your Honor. I used my client's federal tax rate. I used the state tax rate, and she works in the city of Battle Creek. And so she has the 1% tax. Again, the 25% is more favorable to Mr. Klein than if we took the specific tax rates, but we're willing to go with the 25% if the court is so inclined. And so to try to synthesize what we're talking about, Your Honor, is I would say, number one, Mr. Schaefer and I are on the same page with ultimately the amount of money in post-tax dollars that are owed by Mr. Klein to Ms. Klein. It's, again, he's not willing to go along with this notion that the court on 2 occasions specifically made reference that these numbers are to be offset. So that's number one. Number two is now we're talking about how is that money going to get paid? In my judgment, I said that the offset should be against the retirement. However, based upon the objection filed by Mr. Schaefer, if we're talking about alimony and gross, I think the far easier way would be to simply offset $16,094.11 against the alimony obligation. And then we can give up talking about gross ups and whose tax rate should be used. If the court is disinclined to go that way, then it's illogical that Mr. Schaefer's tax rate enters into any of this because it's the impact on my client that we're talking about. If the court is inclined to use the tax rate of Mr. Klein, I go back to the IRS tax table, and this additional income to him based upon his current rate of income, the federal part of that would be 22% alone, and then we move to this up to the state level. And I think that the easiest way would be to offset the money against the alimony. However, if the court's not so inclined, I'd argue my client's tax rate should be used. If Mr. Schaefer's client's tax rate is going to be used, it starts at 22% and not 12%. So I would move on. We've talked about the attorney fee. Clearly, the ruling of the bench was offset should be work in this case. And again, I go back to the very end where the court made it clear, pursuant to Mr. Schaefer's question, that the attorney fee was going to be subject to offset. We talked about the Cigna stock awards, and I went back and looked, and Mr. Schaefer is correct as to the years that were talked about. I don't think it makes a difference because in regard to the Cigna award, that was an area where the court was absolutely crystal clear on the amount of the stock that his client had an interest in. So as the court made its ruling, there was a specific number that was used, and that was the $1,342.20. Both of our judgments identify that fact. It was simply the continued statement when we're talking about the Cigna stock. And again, I went back and looked at this, and the court first of all identified that one quote, $1,342.20 would be payable to the defendant. And plaintiff, my client, is entitled to 2 additional stock distributions, one on March 1, 2024, and one on March 1, 2025. I added in 2023. I'll acknowledge that. I think it should be included. I don't think at the end of the day it makes any difference as it relates to the objection. The page 2, the communication regarding how these parties are going to try to communicate. Again, court, quote, the court would order that the parties would communicate through an app, and I will leave it up to them, whether it is Our Family Wizard or WhatsApp or some other third-party app. If not, they can bring the matter back. That was what the court said, and if we're going to have to come back to court to identify what app we're going to use, then so be it. So I would acknowledge that that was the ruling of the court, and my order was specific. I wish there was an alternative that was suggested by Mr. Schaefer, to be totally honest, but that hasn't come forth. So that addresses the communication. I will acknowledge again that the court did not say we're going to use My Family Wizard, but so that needs to be changed. I've already talked about the equalization. Mr. Schaefer's objecting to the support, but again, the court was very, very clear. And I guess he's waived that objection because he hasn't objected to the support orders. But the court made it clear that what it had in front of it was the 2021 income. And I went through and looked at the exhibits that were admitted into evidence, and there was no year-end 2022 that was admitted into evidence. And the court said, well, if Mr. Klein moves, you'll have to come back in. And so if the idea here is if these objections are that this judgment has to have full fidelity to every word that was said during your ruling, then I would say that if the 2021 income is appropriate in establishing support, and both of our orders actually reflect that. We've talked about the equalization amounts. That leads us to the personal property. So in regard to the personal property, Your Honor, and I would reference, it was 12/14/22 hearing, beginning at page 85, where I was cross-examining Mr. Klein as it relates to the property. And I'll now refer to your ruling on the 14th of February. And it's, and I'll quote, plaintiff has complained that she didn't receive all of the items on the list that she was to receive. The chop saw, the other was a Milwaukee grinder, there was a leaf blower, and I believe there were a couple of other items as well. And I'll say that again, I believe there were a couple of other items as well. And those are the items that I addressed during my cross-examination of Mr. Klein. And what I would say is that my judgment included the items that were referred to during that cross-examination. And perhaps the easiest is the ratchet straps on page 91 of the transcript from the 14th of December. Mr. Klein goes on to say, give them all to her if it makes it. So I included those items that were referenced on that particular date. The keys to the Raptor, the testimony was that Mr. Klein had the title and the keys and we wanted them back, and I included that. And I would say, Your Honor, that I did then bring that up after your ruling. And I had a question in regard to the Raptor. The testimony was that both the title and the keys are within the defendant's possession. Could the judgment provide that those items be turned over within 30 days? Your response was, quote, you can include, Mr. Toth, in that standard provision about the parties cooperating. Well, I didn't include it in that paragraph. I included it just on the list of personal property. Keys and a title are personal property. So I'm not sure if the objection is that I didn't include the Raptor title and keys in another portion of the judgment, or if it's that his client shouldn't have to turn it over and or it shouldn't be referenced in the judgment, Your Honor. So, Your Honor, my belief is that the court made it clear that there were other items that my client claimed she didn't get, and that's why I included those in the judgment. So what took us, Your Honor, the better part of a year to get through with testimony, I think now there are extensive objections, but I think we really have an opportunity to simplify this. If we offset attorney's fees, and if we offset the Cigna stock, and if we offset what the defendant it owes my client against the alimony award, then we can just simply have the $41,000 transferred pursuant to the language that you had in your finding on the retirement money, and that makes it easy. If we're going to go the transfer pre-tax dollars to my client to make up for post-tax dollars, there has to be a gross up. And I've identified 3 ways that I've looked at it, and I don't think any of them make a heck of a lot of difference at the end of the day. I would, Your Honor, like an opportunity at some point this morning to have the court offer some clarity on perhaps another issue, and that has to do with the parenting time schedule. Your ruling changed it. It was actually just about a month ago. My experience over 35, 36 years, however long it has been, is that when a judge makes a ruling from a bench and on a parenting time schedule, the parties adopt it. Consistent with everything in this case, Mr. Klein insists that until the judge's name is on an order, that the temporary order applies that relates to parenting time. So I would ask, Your Honor, whether it's now or whether it's some other time, if the court could offer some clarity, because it's creating another huge issue. My position is simply that the court's identified what the schedule should be. It should be effective now, because it could be another month before we get this judgment signed. Thank you.
Okay, thank you. Mr. Schaefer?
Your Honor, again, I guess the history of this is that it took us the better part of the year to try this thing. There was a lot of testimony. And I guess let me address the argument of easy versus what was ordered. The 2 items, the attorney fees and the spousal support. I believe that Your Honor's ruling was the offset of property. That's what Mr. Tove read when he went back. This is not property. And there's a distinction. Easy is not the remedy here, is that the attorney fees and the spousal support were there to assist current money obligations. Especially the spousal support was a transitional time period because of the lack of income and the lack of property that he was awarded in this particular matter. To say, oh, let's just set it, that is easy, does not help out the current cash flow. And that's why the spousal support should be that which the judge ruled, which is $1,000 a month for 3 years. That is important to my client to have a cash flow, not in some retirement program that he will benefit from when he is 60 years old. Same thing with the attorney fees. As argued at the time that they were awarded, there have been substantial attorney fees in this particular matter. That is a current financial obligation that my client has. It makes sense that it not be offset, and the court did not do that. He set a time that the attorney fees should be paid within 90 days. I asked that be continued. All the other offset had to do with trying to justify the property issues in this particular matter, and they should be. Now, I don't believe that I missed the $12,000 figure. Go back and review that. I think I spent a lot of time just verifying numbers, and I'll give Mr. Toth credit. I think his numbers were on the money, but it took me about 3 hours to go back and review each of those numbers. I don't agree with his equalization chart. I don't think that was accurate. I suggest that my equalization chart is accurate in that regard. We did it different ways. In all due respect, I think mine is a simpler way to acknowledge what was. I took the assets, practical standpoint. His client is getting all the current money in this particular matter. My client, only thing that he gets are assets that are in property form at the present time. And so I think it is important that number be accurate in this regard. And I think mine is accurate in that regard. I will, at the argument of Mr. Toth, go back and review my numbers again, but I don't think that I missed that matter. In response to the other items, yes, I think they ought to be accurate based on your Honor's ruling. In all due respect, I did object to the amount of income allocated to for child support. Your Honor admitted that it was the 21 amount, which is inaccurate. The temporary order used the 158 figure and determination. And Exhibit 47 of plaintiffs had the $24,000 bonus plus the other taxable amount, and the 158, I think, was an accepted number in that regard. If that, I agree that your Honor did not order that. If your Honor is reflecting that, I put that in there so it would be changed and be accurate now. Otherwise, once it's entered, I'll be back in front of the court saying, Your Honor, you made a palpable error in this regard, and here's the evidence that it should be made on. I am trying to get at least part of this finalized, and the 158 number is the accurate number that had been testified to by a number of exhibits and the various parties. That is why that is there. I did not change it in my proposed judgment because it is probably a reconsideration motion because Your Honor made a ruling, although I don't believe it was consistent with the evidence. The personal property, in all due respect, there was a list of property that was stipulated to that each party got, and that was by agreement. And there are a lot of items on that going both ways. In all due respect, they haven't been all divided up yet. Your Honor made a interim ruling about 3 items. That was Your Honor's ruling. That should be accurate in the judgment. There probably will be post-judgment motions to enforce. including the $25,000 worth of property of snowmobiles and Rubicons and whatever else that are still in the possession of the plaintiff that should go to the defendant. But again, those are post-judgment matters. So the ruling of the court should be accurate. And that's why the Cigna stock is important that it be accurate what Your Honor ruled. It's important that the wizard or third app be accurate because that's what Your Honor ruled. And we need to deal with that. The fact that you argue, well, it's easier, I didn't get a counter. We haven't got the judgment in yet, and there's going to be some post-judgment things to deal with this. But the attorney fees and the spousal support are not property items, and I don't think they're subject to the offset. And I would respectfully suggest that the personal property, in my judgment, is consistent with what Your Honor ruled, and I would ask that be part of the order. Your Honor, I think we've all spent a lot of time trying to deal with the numbers in this particular matter. And I think as best as I have been able to cipher through review and Your Honor's ruling, I am submitting that my judgment is appropriate judgment should be entered. I take exception that Mr. Toth is bringing up ancillary issues at this point in time. There's going to be a lot of post-judgment issues, and I ask that it not be ruled on today because there is important input in this particular matter. And there may be requests for additional things to take place based on the change in circumstance over this 9 months that we have tried this particular matter. Your Honor, those are my responses. I would respectfully indicate that my judgment is consistent with Your Honor's rulings, and I would ask to be entered.
Okay, thank you. Well, what the court's going to do is the court does note, and Mr. Toth has referenced the record, which is helpful. The court did intend to, again, offset issues concerning property. I didn't intend to offset the issues concerning the attorney fees or spousal support, as the court had stated that, again, the attorney fees of $5,000 would be paid within 90 days of the finding. So, yes, I can understand the language, but it wasn't the intent that that would be offset or that the spousal support would be offset. The court would not offset those two particular matters. The personal property, that issue, the court had intended that would be the property that the parties had agreed upon at the prior hearing. I think that was the December 14, 2022 hearing that we went through the property, et cetera. I don't think there was a dispute on that, although there was a dispute as to what property that was going to the plaintiff, what the defendant had, and that was the intent for clarifying with some of those other items. But the court would, in fact, order that the items that the parties agreed to and put on the record at that December 14, 2022 hearing would be the property that would be exchanged. And if it's not, then again, the party would be responsible, the opposing party would be responsible for the value of the property not exchanged. That would include the title of the Raptor and the keys, which Mr. Toth had apparently included on his list. That's fine to put it on the list so that those get exchanged and provided to the plaintiff. As it relates to the communication app, I think the language as referenced by Mr. Toth was correct. It was Our Family Wizard or another one if they could agree. If they can't agree, then it would be Our Family Wizard. I guess Mr. Schaefer will have to look back to see if the reimbursement of the $12,556 is included in those particular numbers that Mr. Toth has provided. If they're not, then it should be. But if it is, then you can basically do that. The court would likewise, as it relates to, equalization, if in fact we're dealing with pre-tax and post-tax, the court does believe that there should be a reduction for equalization based upon tax rate. The court does believe that the 25% that Mr. Toth used is appropriate in this matter for reduction purposes, and the court would so order. again, I don't know what that leaves us in the end as far as the total, and I don't know if the attorneys do at this particular point until it's recalculated and refigured, but I think that addresses all of the objections in this matter. And I would address the fact that on income, the court had used the plaintiff's 2021, as I stated, as I reviewed the records and stuff, that is all that I had. I didn't have any 2022, which the court would utilize again in the future in the event that that's brought forward, and that's changed. But as of the time of my ruling, I was using the 2021. Mr. Toth, does that give you a better understanding as to what you need to do to recalculate all this and to prepare a revised judgment?
I do have, I would like a bit of clarification, Your Honor. What I can say immediately is that my calculation with the $16,094.11, included giving Mr. Klein credit for the attorney fee obligation. So that number is going to change with the court's ruling because so there's going to be a $5,000 change there. I understand the 25%. Your Honor, as I understand the ruling in regard to the personal property.
Well, the intent, Mr. Toth, as I stated, is back on the December 14th, when again you cross-examined the defendant about all of the items of personal property, but we had an agreement we placed on the record as to those lists. Again, I wasn't going to go through each and every item of personal property. The intent was whatever the list was that we had that they agreed upon, that would be the list of personal property that they would each get. And in fact, because your client had testified she didn't have various items, that the court ruled that those items would be turned over, or that in fact there would be a value ascribed to those and he would be responsible for that. I tried to do the best I could based upon all of the testimony documents we had.
Your Honor, what we had in this case is we actually had an order that divided personal property and that was entered months before the conclusion of the trial in this case. The list that I went through on the 14th were items from that court order that my client never received.
Okay.
So it wasn't necessarily limited to what stipulations were placed on the record on the 14th, because it basically governed the titled, other than the walk behind mower, it was all things that had been titled. So I just wanted to make it clear, as I understand, the judgment should include
it should include that order that we did, which was the list of those items.
And that's in there. In regard to, for example, we talk about the drone and the ratchet straps and gun safe with key and shop lights, et cetera. That should, if I understand what your ruling is that should not be included. It should simply be the items that you specifically identified. And then I should add a provision that says, in addition to anything that was placed on the record on the 14th. And I guess my question is there was no stipulation regarding placed on the record on the 14th regarding drones and handgun safe, et cetera. That had been memorialized by a previous order.
Right.
My concern
we'll go back to that order.
Okay,
my concern is to go to the order, which was the agreement on those two lists.
Got it.
With the exception of the testimony onto those other items.
Got it. Okay, I understand. And as I understand it, I can specifically include the title and the keys to the Raptor.
Correct.
And let me just, I only want to do this one more time. Your Honor, I had asked for some clarity regarding the implementation of your order, and that's not outside of anything. We have a problem. We have a problem with Mr. Klein playing games where my client gets a call. My client needs to know what the parenting time schedule is, and consistent with the practice in this county and every other county I practice in. If the court makes a ruling regarding parenting time, it should be respected from the time of the ruling. That's simply my question. That's simply my question, Your Honor.
Okay, was the intent that ruling would take place, it would be effective the date I gave the ruling, notwithstanding. I mean, if you'd have had the judgment done in a day, it would have been in effect that day. If it took a month, again, the ruling would still be effective. But again, the court ruled on the parenting time, and that's what I expected the parenting time to be.
And that would be effective presently then, Your Honor?
Yes. Can
Thank
be
you.
effective present. Okay,
Your Honor, I have some responses, please.
okay, go ahead.
On the personal property, I believe Your Honor said that whatever's on the order that was stipulated to. And
Correct.
it was for both clients, that if they are not turned over, then the value would go through and it worked both ways.
I'm not going to utilize that one way and not the other way.
Okay, very good. So it's both ways, that they are either turned over the value, that correct?
Yes,
Okay, very good. And you made comment about the wizard and the third act. You said that you thought that Mr. Toast's language was accurate. I don't believe it is. He says it is the wizard. And
no, I meant when we were talking about, he referenced the ruling, and that would have been the correct determination on that. It would be our family wizard or a third app, whatever the parties could agree that, and if they can't, and I said at that point, if they can't, then they can bring it back and we'll make a determination.
Okay, very good. Thanks for that clarification.
Okay. Thank you, gentlemen. We'll end at 10:15 a.m. You're free to go ahead and get defendant's motion for temporary custody and parenting time. Court does note, as I reviewed the file, that there is an issue as it relates to the paternity as well of one of the children. Court will, on that issue, as order that the parties would submit to DNA testing with the child and with them respectively. Parties will pay 1/2 the cost of that testing, subject to later reapportionment. Now, Ms. Henderson, you can proceed on your motion.
The parties have separated a long time ago, over 2.5 years ago. And since that time, my client has been an active participant in the children's lives. The children are relatively young, and the parties have actively participated both in the raising of these children. The children are currently 5 and 3. And Your Honor, my client is seeking joint legal and joint physical custody of the minor children with the parenting time of a week on, week off type variety. It should be noted for the court that since approximately December until last week, my client has been blocked on plaintiff's phone and plaintiff was refusing him parenting time. Only upon Ms. Moss's involvement, my client was able to get 1 weekend parenting time, which occurred past weekend, and it went really well. My client works at Denso. He works second shift. However, he has a sister that is able and willing to provide care for the children when he is at work. His regular parenting time schedule is from 11 p.m. until 7 a.m. So he would be able to spend time with the children both after school and in the morning to get them ready for school. Up until December, the plaintiff also worked at Denso in also third or second shift. So the parties essentially had very similar incomes and very similar work schedules. It is my client's position that in preparation for filing for divorce, plaintiff got fired from the Denso job and has been staying home doing odd jobs from the house with the children after filing for divorce. However, it is my client's understanding that plaintiff is seeking for factory type work. So essentially the parties may be in the same position again, where both of them are working in a factory type schedule. Your Honor, we are asking for the parties to share joint physical custody as my client is able and willing to provide care for the children and has provided care on a regular basis, essentially exercising equal or close to equal parenting time since the separation in 2019 up until December of 2022 when plaintiff refused him parenting time. We're asking if any child support is to be ordered, that Ms. Calderon be imputed at her previous income at Denso, which essentially is income very similar to my client's, and otherwise that child support be ordered in accordance with the formula. My client is stating that the joint physical custody and joint legal custody with equal or close to equal parenting time would be in the best interest of the minor children.
Your Honor.
First of all, this is not a recent separation. The parties have been separated for over 3 years. And for that entire time, my client, the plaintiff, has had the established custodial environment. She has been the sole provider financially and in terms of care for the children. She's taken them to every appointment. She puts them to bed at night. She gets them dressed. She provides all clothing, all food without support from the defendant. The children are accustomed to looking to her for support, and that is the status quo and has been for over 3 years. And that includes when she worked the same schedule as the defendant until December, when she was unable to maintain that employment due to mandatory overtime, and her mother, who helped her with childcare, started her own job. Currently, my client works in her home after the children are in bed so she can complete all parenting duties. However, plaintiff is very willing to agree to defendant having substantially more parenting time than he's exercised in the past. At this point, she has suggested every other weekend from Friday at 6 to Sunday at 6, and once a week on Wednesdays for a 2-hour period that the parties agree to. It's important to note that my client offered defendant parenting time frequently, and he declined it. Defendant's proposed parenting time is very disruptive to the children and the status quo. Despite offers from my client, he has not had the children for an overnight since the separation. My client estimates that he would typically see the children once a week for about 2 hours at a time. This proposed schedule is further disruptive as it requires the children to go to defendant's sister's home for the overnights, where she has, I understand, 3 children of her own, even though plaintiff is available. Plaintiff has absolutely not withheld the children from defendant. There was an issue that she had a second phone and requested defendant to use the new phone number, but he did not. Over the separation, defendant has not answered plaintiff's text offering parenting time, but he has answered texts about their truck. So plaintiff has been solely responsible for the care of the children since the separation, and defendant has not been involved in a predictable or consistent way. We are asking to preserve to some degree the status quo, but also increase defendant's parenting time to every other weekend and 1 weeknight for 2 hours. This gives defendant parenting time when he can actually interact with the children rather than leaving them with his sister. We agree to comply with child support based on the child support formula, but would like my client's current income used. And we agree that the minor child needs to be excluded from the marriage. And we agree with joint legal, joint physical custody. Thank you.
Ms. Moss, the last statement you said, we agree to joint legal and joint physical custody. Is that correct?
With the parenting time as we suggested, correct?
Okay. Ms. Moss, just to clarify, you said that the defendant did not have any overnights since the separation back in August of 2019. Is that accurate?
That's my understanding, yes.
Okay. Is that what you believe to be accurate, that your client had no overnight since the separation?
That is absolutely not accurate, Your Honor. My client exercised on average 3 to 4 overnights per week, which is why I said that their parenting time has been equal or close to equal. They didn't have a set schedule. They both worked the same shift. And up until the end of December of last year, during plaintiff's work hours, her mother provided care.
Please let the interpreter.
Oh, I'm sorry.
Hold on a little long there.
I apologize. If you need me to repeat, I will. I apologize. Mother provided care during the night when both parties were working. So that situation, that status quo continued up until about 2 months ago.
Well, what the court's going to do in this particular matter is I am going to, pursuant to the agreement and the understanding of the parties, is grant to them joint legal and joint physical custody. And the defendant's parenting time will be on the weekends from Friday at 6:00 p.m. to Monday morning at 9:00 a.m. and Wednesday for a 4-hour period to be agreed upon between the parties. Court will also order standard alternating holidays, spring break, summer break, etc. Court will set, again, support consistent with the income of the parties when the plaintiff was employed at Denso, subject to later modification based upon testimony at a subsequent hearing. Anything else, Ms. Henderson?
So my only question, Your Honor, with spring break coming up in a week or so, could my client please be granted that in this year since he missed so much parenting time due to?
We could do that. We'll grant him spring
Thank
break
you.
this year and then alternate thereafter. Ms. Moss, anything else?
No, Your Honor.
Okay, thank you. I'll ask Ms. Henderson that you would prepare that order and submit under 7-day notice.
Thank you. Your Honor, for the child support, should I make it effective upon entry?
That would be fine.
Okay, thank you very much.
Court will end this matter as motion 10:38 a.m. You're free to go. I have reviewed the motion. I've also reviewed Ms. Henderson's answer. Is there anything else that you want to add, Ms. Huffman?
Not anything else specific. I just wanted to do a quick summary if I might, if the court needs it. Otherwise, I won't, but
Okay, now if there's something you want to point out in summary, go ahead. I just don't need to hear the motion again.
Basically what I wanted to point out is that this 2 weekends in a row that this minor child has been trying to have parenting time. It's not like dad is preventing this. Dad is taking this child, but mom is refusing to allow the child to bring his phone, which this court has already ordered that he be allowed to bring his phone. So it is extremely detrimental to this child's well-being. We already have the one child refusing to go. And like I said, dad keeps talking this child into going, even though he's afraid to go. And his mom states in an email that she's afraid of the child as well. So I don't know what we're doing here, forcing this toxic situation to continue. It has to stop. It should not even be a question at this point. So we're asking the court to suspend parenting time at this time, or to order supervised parenting time with the maternal grandfather. We would also ask for attorney's fees in this matter. I know we didn't specifically ask for it, but we did ask for any other relief the court deemed appropriate in the matter. And in that case, we would ask for $620 for the filing fee and the amount of time it took to do the motion.
Okay. Ms. Henderson, what's your response without reiterating your answer?
Thank you, Your Honor. In this matter, the court has ruled that the minor children are to have access to their mobile phones in the respective parents' home. My client has a separate phone to use for the minor children in her care. They each have a phone in her care. The court previously has ordered that the parties are to engage in co-parenting counseling with Dr. Haugen. My client has participated at this point in at least 3 sessions. The recommendation of Matt Bosher, to whom Dr. Haugen referred the counseling to, is that each party keep their phones at their homes, that the children have phones to use in their homes, but they don't take them back and forth to prevent the disputes about that, Your Honor. So she is following that recommendation. She informed Mr. Depew about that recommendation. We are unsure if he actually engaged in any sessions at this point, but my client has followed through with the order and has actively engaged in counseling. There is absolutely no evidence that parenting time is harmful for the children. And that is the standard that the court has to use when considering suspension of parenting time. We're dealing with a defiant teenager. Or 2 teenagers at this point, Your Honor. Co-parenting counseling has been requested and ordered. My client is following through with that. So that is an issue that needs to be brought up and worked through the counseling rather than getting the court involved endlessly in this matter. One point that is asked for in the motion at this juncture is that Cameron is included in the counseling. It has been done, even though Mr. Depew did not specifically ask my client permission to enroll him in counseling, but the child is attending counseling, and my client is in touch with a counselor regarding the children's counseling at this time, Your Honor. Further, I want to point out that this motion is verbatim, a motion that has been denied a week prior with a different title, and that week prior, the motion was filed as ex parte motion to suspend parenting time. Your Honor, Mr. Depew is trying to cause my client further emotional distress, further disparage her in front of the minor children, and cause her additional attorney's fees, which we're requesting in the amount of $700 at this point. Further, Your Honor, we have included some reports that refute the statement that my client is abusive to the children or that she is not following the court order. That is simply not true. So at this point, Your Honor, we're asking for the motion to be denied in its entirety due to no harm caused to the children or no showing of that harm caused to the children. My client is following the co-parenting counselor's recommendations as she was ordered to by the court. And Your Honor, we're asking for attorney's fees to be granted due to continuous filings of the motions in court, even though this matter is currently being addressed by the co-parenting counselor as was requested by the defendant previously, Your Honor. Thank you.
Okay. What the court's going to do is the court is going to order that the children, and that would include Cameron as well, would continue in with the present counseling. That the court would order that the children be allowed to maintain their phones while in the parent care of either of the parents. So if they want to take whatever phone they have from the one parent to the other, they have a right to do that. We'll put in that there was some issue brought up about the contact between the parents. So the court will state that each parent is limited to one text or one call per day with the children, and the court will reserve on all further relief pending an evidentiary hearing in this matter, which will not be set until such time as we have some counseling and other report and recommendation from the counselor. So, Ms. Huffman, you can prepare that order and submit it under 7-day notice. Court will end this matter at 10:47 a.m. You're free to go. Have a good day.
Thank you, you too.
Your Honor, just to clarify, the court is not making any determination on parenting time, suspension, or change.
Before the court on the plaintiff's motion for modification of custody and support. The defendant has not appeared. It was set for 9 o'clock. It is now 10:52 a.m. Court will find, based upon the petition, that there is sufficient proper cause change of circumstances to meet the threshold of ABARCA for an evidentiary hearing. The court will refer the matter to the referee for an evidentiary hearing. Is there anything else, Ms. Podolsky, that you need?
Nothing for today's purposes. Thank you.
Okay, we will do that order, and we'll end this at 10:52 a.m. You're free to go. Have the appearance of Ms. Reed in place of Mr. Umlauf in this matter. The matter is before the court on the defendant's motion for temporary suspension of parenting time. Ms. Reed.
Thank you, Your Honor. In respect for the court's time, I'm going to largely rely on our pleadings, but my client has serious concerns that plaintiff exercising any parenting time poses an imminent threat to the health and safety of the children in this matter. She has a serious history of drug use, which was current up until my client last saw her, which is on around January 22nd of this year, when she was found beaten and appearing to be under the use and influence of heroin. She's currently in a violent relationship with a gentleman who has perpetrated violence against the plaintiff in front of the children and also chased the plaintiff in a vehicle. We believe these issues with the drugs and the violence are continuing, that she does not have a stable home or environment for the children. The children aren't attending school while they're in her care, and so we're requesting that her parenting time be suspended until the evidentiary hearing on April 25th.
Okay. Ms. Cornely, what's your response?
It's all lies. I mean, the school, the week that he accused me of, the 16th through I believe it was the 23rd, my oldest daughter had strep, and Madison has stomach issues, which Justin has actually kept her out of school for multiple days since she's been with him, and he's been withholding my parenting time. I've turned in a motion of him denying my parenting time. I filed that, I believe, 2 weeks ago. He has held her from me since the end of January. I live by myself with my kids. I was in a relationship. It was not good, but the kids were not involved. I am not with him any longer. It's just me. I have a full-time job. I'm not on drugs. I will subject to a full drug screening.
Okay. Anything else, Ms. Reed?
Yes, Your Honor. It's my understanding that the plaintiff hasn't done anything to exercise her parenting time since the 22nd of January. She has called approximately twice for 1 minute each phone call to talk to the children. She has not requested her parenting time, and it's my understanding that she also has an active bench warrant out for failure to pay child support.
Okay. Well, what the court's going to do is, at this point, we have again, an evidentiary hearing coming up in April. The plaintiff has stated that she lives by herself, that she's not in that relationship which apparently has caused the issues in contention, et cetera. The court is going to deny the motion at this time. And the court would order that her parenting time would resume. I don't know if that's Wednesday or Friday this week, but
It would be Sunday.
what?
It would be Sunday. It's Sunday to Sunday for us.
Okay. The court would order that that would resume then on Sunday and would continue until there's such time as we can have an evidentiary hearing. So that will be the order of the court. I'll ask Ms. Reed if you'd prepare that order and submit that under 7-day.
Yes, sir.
Ms. Podolsky, on this matter at 10:57 a.m. This is before the court on the plaintiff's motion to set aside referee. Or set aside, is this the default or the referee recommendation? Mr. Jones, just so you know, as Ms. Podolsky has pointed out in her answer under Court Rule 3.215, that your motion has to contain a clear and concise statement as to any error that the referee made. You can't simply set aside the referee recommendation because you don't like it. You have to have some legal or factual basis. What is your legal or factual basis for seeking this to set aside the referee recommendation?
Well, there's a decision last year from February that it was just based on my residency. And then I come in with residency thinking that I could have my joint custody back. And then here now I'm being told that 1 month out of residency isn't good enough to have my joint custody back. So, I mean, I'm under a year lease. I've had my employment for 6 years. There's no reason why I shouldn't end up having my joint custody back.
Thank you, Your Honor. There was a motion last year to modify custody, parenting time, and support. There was a full evidentiary hearing held. This decision was not based solely on the plaintiff's residency. It was a major factor, yes, but it was not the sole basis of that decision. The referee made a decision at this time that became the new order of the court. His current motion simply stated that he has a residence now and should have joint custody again. The referee agreed that that did not meet the standard as set in Vodvarka to change custody and parenting time. And now again, as the court has stated, this current objection, this motion to set aside the referee recommendation does not comply with court rule. It does not state a clear and concise statement of specific finding or application of law that the referee made. That was an error. So we are asking the court to deny this motion and uphold the referee decision and continue the current orders of the court.
Okay, Mr. Jones, any response?
So, like, he was basically saying that 1 month isn't stable enough, but that's not written into law what is defined as stable enough. You know, I've been through this, the kid's life as a stable father. I've been here. I've been through athletics, traveling. I do my parenting time, Thursday dinners. Boys are no longer really children. They're adolescent young men. They need to be respected as where they would like to be, when they would like to be. They want to be back home with dad. You know, I get home, like, here's a bedroom, brand new beds. Over at Sarah's house, they sleep in a basement. Torrin is sleeping in a closet in a bedroom without egress, without fresh air, like no windows, sleeps in a closet. But here, yeah, I get a stable home. And then where in the law is it written that there's a time period? Like, all I know is based on my residency. The time I had no residency last year, now I have residency.
Okay. Well, what happens in this case, as you probably know, is the referee would have went over under MCL 722.23. There are 12 factors the court looks at to determine, again, custody in this particular matter. Again, the stable, satisfactory environment is just one of those particular factors. And you have not, when the referee, again, utilized that and said, well, that 1 month was not sufficient, the court cannot see any error on that particular factor based upon what you've presented in this particular case. There may be other factors. Again, stable, satisfactory environment is one factor, is one of the 12. And as a result, the court is not able to find error on the part of the referee based upon your maintaining residence for 1 month at the time of that particular hearing. Not to say that it couldn't, but again, that is only one factor under the, again, Child Custody Act And as a result, the court does not find any error by the referee. So the court will in fact deny the motion to set aside the referee recommendation at this particular time. And that will be the order of the court. We'll end this hearing at 11:05 a.m. You're free to go. Have a good day. Court will note the appearance of Mr. Magnuson in this matter on behalf of the front of the court. The matter is before the court on the plaintiff's motion to set aside referee recommendation. It basically states, Ms. Coleman, that again, you had some issue with regard to, or Mr. Coleman, you had some issue with regard to, again, the DNA and all of that. Is that correct?
Yes, yes, Your Honor.
Mr. Magnuson, what's your position on this?
Well, Your Honor, what we could do, our office can facilitate genetic testing. This is an action under the Paternity Act. I would simply suggest that the order remain in place. It is a zero order, taking into account the defendant's incarceration status. And I believe that we could accomplish the genetic testing and take care of that issue while the order remains in place. And if there is an exclusion, we can deal with that down the road.
Okay. Plaintiff, is that something that's agreeable?
Yes, I would just like a genetic test of me and Calhoun Samuel to be for sure that that is his son.
Okay. Well, let's do this. And I guess I'll ask Mr. Magnuson if you could prepare an order for DNA testing and that the parties and the child would cooperate to accomplish that. We can get that done, that the order will remain in effect at this point until we get the results from the DNA testing.
I can do that, Your Honor. And I believe I heard Ms. Coleman indicate that Mr. Samuel had been moved to another facility.
She did early, yes.
Ma'am, if you could let me know what the name of that facility.
He just came back to Newaygo in White Cloud, Michigan.
Okay, very good.
Okay, thank you.
Thank you.
Court will
Thank
end this
you.
matter at 11:08 a.m. You're
A
free
few
to
more
go. Have a
minutes
good
if
day.
they can't connect anymore.
Put it over and they'll have to contact us next week.
I think this is the second time they.
Yes, ma'am. This is the second time this has happened.
I'm giving them the telephone number and asking them to call in and appear via telephone.
Ms. Hunter, we've attempted to have the defendant connect vis-a-vis telephone, which is usually the easiest way to connect, and they're not able to do that either. So again, the court is required to make all attempts to get them to connect. So what we're going to probably have to do is, fortunately, adjourn the matter one more week, and we'll be in touch with them by phone and tell them how to connect by phone rather than by Zoom, because they're not able to do that apparently. So.
Yes, that's what happened. We've done this, I think, 2 or 3 times.
I understand, but well, we've done it once before, so we have to give them opportunity, and they obviously are trying to.
Audio.
Hello?
Yes, I'm here.
Okay, sir, just so I don't murder your last name, how do you pronounce that?
It's called My Chuck.
My Chuck?
Yes.
Okay. This matter is before the court on the defendant's motion to set aside referee order in this matter. Again, sir, we don't set those aside simply because you disagree with the ruling in the particular case, but you have to establish that there's a factual or legal error for doing that. So what do you believe to be the factual or legal error that the referee made in this matter?
No, the last time we hooked up, I wanted to get a DNA test. And my income, you guys got my income wrong.
Okay, well, let me tell you, again, that's why we have hearings, so you can come there and present that. You weren't present at the hearing. So, don't look at it as our fault that we don't have the income correctly when you don't appear at a hearing.
Okay, what hearing was that, sir?
Referee hearing, the one that this resulted in this order.
Okay.
Okay.
Ms. Hunter, are you opposed to a DNA test in this matter?
Yes, I thought he did it a long time ago, but I guess he didn't.
Well, okay. To say I thought it would, we don't know. Okay, if again, he's claiming that there was no DNA testing, what happens, the court will order DNA testing in this matter of the parties and the child. And I'm not going to do anything with the order until such time as that DNA is completed, because if the DNA shows that he is in fact the father, then there's no reason to change it. Court will order at this point that Mr. Marchuk would be responsible for the cost of that DNA testing. Mr. Marchuk, I'll tell you, you can contact the front of the court, and sometimes in some types of cases, they can assist in having that, testing done. So again, it's be a minimal, if any, cost in this matter, but I don't know if you fit with under the provisions whereby they would in fact accomplish that. So you're going to have to, what you have to do is contact the front of the court's office, talk to a Mr. Magnuson.
Okay.
He can tell you whether that would be something that the front of the court would do. Okay. If not, then you're going to have to, then you're going to have to acquire the DNA test yourself at your expense.
Okay.
Okay.
Yep.
Okay, we'll proceed to that point. That'll be the order of the court. The court will end this matter at 11:19 a.m. You're free to go. Have a good day. Hey, Mr. Joseph, enlighten me what's happening in the case and where are we at?
Yes, Your Honor. We there was a contract for the sale of a business, and unfortunately, the payments were not made, and there was an arbitration clause within the contract. We attempted initially to have Miss Flynn, if she would agree to waive that so we could get it settled, but she did not want to waive it. We had arbitration. There was an award for $28,500 entered November 17th, 2022, along with $862.50 in reimbursement that my client was forced to pay Miss Flynn's portion of the admin fees in order to have the hearing. After that point, we have not received any payments. There was initially Miss Flynn was going to drop off $100, I think, to start payments, but we never received that. Thus, we filed with this court to have the arbitration award confirmed. And that's kind of where we stand right now. It looks like we do have our complaint, and Miss Flynn did file her answer.
Okay, so we do have an answer then. Okay. Miss Flynn, what's your understanding? Where are we at?
That's pretty much it. And when the contract broke down, my lawyer I had at the time was trying to help me settle with the plaintiff before going through anything at all, but we couldn't come to terms there. So then we went through the arbitration and they got their award. And now we just want to confirm it so they can garnish or whatever they have to do.
Okay. Why don't we do this is, Mr. Joseph, we have our motion days on Monday. And why don't you check with my office and see a time available? Why don't you bring in a motion to confirm that? We'll set it for like a Monday at like 11 a.m. when we don't have another hearing. That'll give us a little bit of time if there's anything we need to take other than the motion itself. Okay.
That sounds good, Your Honor. Yes.
Okay. That way, if we had to, we could get some brief amount of testimony if necessary.
I will file that immediately, Your Honor.
Okay. Thank you. That's all we'll do today, and we'll wait for that, and then we'll schedule and take care of it at that time.
All right. Thank you, Your Honor.
Okay.
Thank you.
Thank you, Your Honor.
Versus Gregory Rupel Jr. Today is Monday, March 13th, 2023 at 1:40 p.m. Attorney Lisa McNiff represents plaintiff. Defendant is attending via telephone.
Okay. I'll go to plaintiff first. Ms. McNiff, what's happening in your case, or what is not happening in the case?
Your Honor, we submitted a default request on March 9th, so that was Thursday. And of course, there hasn't been time for us to receive that back. I have prepared a judgment. The parties are not in agreement with regard to the judgment. There are a few things that that they would need to work out, or if Mr. Rupel is defaulted, my intent would be to submit that.
Okay. Mr. Rupel, what's your position?
I just received a copy of the form yesterday. I reviewed it, and like she said, there hasn't really been time to go over anything or respond.
Well, you got served, and so you better take the time because the matter is moving along quickly. And we're not going to wait for you to, again, to get a convenient time to proceed. If she served.
I just got it.
What?
I just got it yesterday.
You got served yesterday?
No, I didn't get served at all.
The default, probably.
Okay. Well, what happened, sir, she says they served the default. What happens, you would have been served and you would have had 21 days or 28 days, depending on how you were served, respectively. So you've had time to respond. All I'm going to say is you need to take action to respond, or otherwise a default will get entered against you. You understand that?
Sir, I haven't been served, sir. I don't know what do you mean served? Like a person come to give me paperwork? Like served like that? Because that hasn't happened.
Well, what did you serve then, Ms. McNiff?
Oh, Your Honor, Mr. Rupel was served with a complaint for divorce. I can tell you quite some time ago. I believe that the document that he's talking about that he received recently was the request for the default, and we mailed that.
Okay.
Oh, you think it was the judgment?
I think it was the judgment.
Well, it also could be, we mailed the default on Thursday, so he may have received that recently.
Well, regardless, Mr. Rupert, you were served with the paperwork, as Ms. McNiff says, for the judgment or for the divorce. You're saying you were never served?
Oh, I was served like last year.
Okay.
But I thought you were talking about something more recent. My apologies.
Well, there is something more recent, but you might not have received it. They sent it out on Thursday. You may have not yet received that. I'm just telling you that when you do receive that, you got to take action, or a default judgment is going to be entered against you.
Okay.
Okay, probably what we're going to do, because this obviously is a settlement conference, we're probably going to set it for trial. Ms. McNiff, how much time do you believe reasonably you're going to need to try this?
I would anticipate no more than a day.
Okay. Mr. Rubel, what are your thoughts on trying the case?
I don't really know.
Okay. Well, what we'll do is we'll set it for 1 day at this point, and if we're not able to get it done within that time, then we're going to have to follow up with additional days. But what we'll do is we'll contact Mr. Rupel will contact you and Ms. McNiff's office and try to find out when the two of you are both available, so that we can set this up and get the matter tried.
Very well.
Okay.
Thank you, Your Honor.
Okay, thank you. The court will conclude, and you have a good day.
Thank you. You too.
Thank you. Thank you, Your Honor.
Good afternoon.
Good afternoon.
Hello. Okay, can everybody hear me?
Yes.
Okay, this is case 2022-3011 DC. Sophia Gilliard versus Vegas Brown. Today is Monday, March 13th, 2023 at 1:46 p.m. Attorney Paul Omloff represents defendants.
Okay. Good afternoon to all of you. I will start with you first, Ms. Gilliard, as you're the plaintiff. Let me know what's happening in the case as best you know.
We did come to an agreement. He would get her every other week.
Okay, well, let me ask Mr. I don't need the specifics. If you could, Mr. Omloff, she says that they came to an agreement. Are you aware of that?
I am, Your Honor. We reached an agreement at mediation. I prepared a child support order and a custody order. My client has signed both orders, but Ms. Gilliard has not yet signed the actual custody order. My staff have called a couple times leaving messages. They're two separate orders that both need to be entered.
Okay. Did it get sent to me in the email? I'm sorry. I did sign one. I know that.
Yep, and there is a second one that needs to be signed.
Okay,
If you
I
like,
will-
I can,
I
Go
could
ahead.
sign it. I could sign it.
and we can resend that to you if you like.
Yeah, I could do
Why don't we
that.
do this, resend that to Ms. Gilliard, and hopefully we'll get that done, and we can get the case concluded.
I'll
Okay?
sign it today.
All right.
Okay. Okay, thank you. We'll give you a couple, maybe 10 days, couple weeks to make sure we do that, and then we'll be pushing you to come back in if we haven't received anything at that point.
Okay, I'll
Understood.
sign it.
Okay, thank you. We'll conclude today, and you can have a good afternoon.